Getting straight into it, 19 past 8. Starting off from Parliament, and just for those who perhaps were not a part of everything that transpired yesterday, you were locked up in a box somewhere, and so you didn't witness what it is that happened. Let's do a quick recap, shall we, of proceedings from Parliament yesterday, when the Appointments Committee had the pleasure of inviting the CJ nominee to appear before it and then answer questions as to whether or not he is fit for the position, because that was a question that was asked him, and so I can repeat. He was asked whether or not he is competent enough to occupy the position as Chief Justice, and the response thereof. But before all of that could even happen, this is what transpired.
Of the caucus, we hear with a heavy heart, but an unshakable resolve to defend the Constitution of Ghana, protect judicial independence, and uphold the rule of law. We gather to vet a disputed nominee for office of Chief Justice of Ghana. This should be a moment of national pride
Chairman,
and institutional renewal.
I have an issue. The ranking member has no right, no lawful authority to raise anything about what happened in court, the processes leading to a removal of anybody and the nomination of anybody. You have no right, pursuant to our rules, to raise those issues. So be guided, because if you raise them, I'm going to object. I am objecting to the use of the term disputed nominee, because there's no dispute before us regarding the nomination.
There are
to you to proceed whilst we exit this committee room with our views well documented for the records, and on the floor we shall proceed with the debate, further stating our position and take a vote against the nominee as required by the rules of the plenary. Thank you very much.
Thank you very much, Minority Leader. But how do you reject a nominee who is yet to be vetted?
Yes. No, she believes in us.
The report is not ready to be voted for. We are not at the stage of approval. So your conclusion is very preemptive.
Yes, Chairman, with respect. Chairman, with respect.
This is not what I want you to respond to.
No, Chairman, but
I don't want your
Chairman,
response
to the extent that you raised it, I just need to.
Honorable Minority Leader,
Chairman,
you have your day.
Chairman,
you have your day. The two microphones should be off.
Chairman,
the two microphones should be off. With all due respect,
we have registered our position.
Honorable Minority Leader,
that we have rejected.
We agreed on your position.
We rejected, and we voted
agreed on your position. Yes. When it is time for voting, then you can vote again. Yes. So we thank you very much, and we wish you a very good luck. Honorable members.
And so that's when the minority filed out, but there's a bit more in terms of the reactions that they granted and what it is that they had to say afterwards. Kwame Enyimadu entries a ranking on the constitutional, legal and parliamentary affairs. Let's take a listen to exactly what he as well had to say.
The way things are going, we think that we don't want to. If you are not careful, and you saw the interjection that I made, if you are not careful, you might even speak against anybody like the majority leader and whatnot, and we don't want to proceed. I don't know when the majority took the decision that when a minority has a position, we don't have to air it. I don't know.
Take this
and it's not right. Let's allow the process. Let's go through the process. All the questions that we need to ask, let us ask them. I mean, that is what civil societies demand, but it didn't work that way.
Thank you, Honorable Chair. I think the image of the judicial service has gone down. A lot of people have a lot of problems with the service, particularly with regard to the fact that cases keep so long in courts. People go to courts hoping their cases hoping that their case will be heard within a very short period. And cases, but there are some now. The average number of years that a simple civil case can stay in court is about 3 years or 4 years. There are some cases that have been in court for so long. There are also criminal cases, as I said earlier, where people are facing trial over a long period. All these affect people's confidence and trust in the service. But as I said earlier, some of them can be tackled because they are institutional problems. Like, we have vacancies for as many as 116 magistrates. We need to fill 116 courts. We don't have personnel. There are some courts that do not have infrastructure. I mean, you go to the courts and then the buildings are in very serious states of dilapidation. I remember last year, over the past 3 years, the District Assembly Common Fund sponsored the building of about 100 courts together with their residences. But it's still not enough. We still have some of these courts built but not occupied because we don't have the personnel. But that is not to also mean that we should throw our hands in despair and say that we can't do anything about it. Admittedly, there are some cases that do not move fast as a result of, as I said earlier, the technicalities associated with our rules and other things. But we also recognize the fact that there are some judges and magistrates who do not put up their best. And all these add to
the best in the morning is on 92.7 Sunrise on 3FM.
And I also mentioned earlier that people are now too eager to go to court. And so we want to, as we want to build courts to take care of the more cases that are coming up. The theme of these meetings was the fact that in 2013, the election petition lasted for almost 8 months. The final decision came on the 29th of August. Essentially, I'm the only surviving member of that panel. Everybody else has retired. The final decision came on the 29th of August. We came to the conclusion that it should be possible to have the election petition concluded before the 7th of January, the inauguration day. And the first suggestion that came, which we think was a masterstroke, was that we should have the elections on the 7th or the 8th of November. If we have the elections on the 7th or the 8th of November, by the 10th, the results would have been declared. If we have the results declared on the 10th of November, we have 20 more days before even November ends. Then 31 days of December, then 6 days of January, making a total of 57 days. Assuming we want to stick to even the 42-day window provided by CI 99, we can have the election petition filed, responded to, and everything tried within the 42 days, because we have 57 days.
And so that's the Chief Justice nominee, Paul Bafo-Boni. There's a lot more he said, but I think we started the conversation during the review segment before we even connect with Christian and the rest of the guys who are expected to join us for this conversation. 3 years, he says, is the average time a civil matter lasts in the court. 3 years. That brings into not really, because I've had the when the Agrada case was finally brought to an end, that also lasted between 3 years actually, and so averagely it's taken 3 years to prosecute successfully a case. Surely this puts into perspective why, for instance, the corruption-related matters and what have you will never see the light of day. And from the conversations, he was seeking to tell us, too many people are also going to court for things that can be resolved with ADR. You can just sit and have a conversation and then you resolve everything, instead of headed to the courts and continuing to put a lot of pressure.
Respectfully, I don't think that is the case.
On our courts.
Ghana, actually, we don't even like litigation. Ghana, we like to... My God will show you. See that thing? We like that thing. So we are not even litigating people.
That's true. But I mean, those are his words, not mine.
Because if you look at the kind of things that are happening in this country, and people don't go to court, they just do and let it be, or they just say, see those kinds of comments. And that's what we do. We just do that, then we move on. We don't. A lot of Ghanaians are actually scared of the court and the court process and system. A lot of Ghanaians don't want to hear anything about court or police station. They don't want to hear. So the moment the thing begins drifting to that side,
then they are backing off.
They are backing off. They say, "I'll beat you, I'll beat you, I'll beat you." But he's saying, "I'll beat you," but he's retreating. He's retreating while shouting it out. So I really don't think that is because people are in court with frivolous cases, and yes, there may be a number of them, but that cannot be the reason. Our rules also even allow for the arbitration, mediation, all of those processes. You say give it a try before you start the formal litigation process. So you can go to court, especially in a lot of the commercial cases. You go to court as part of the rules, the processes. The rules will allow you to first attempt a settlement outside of the court.
For the civil cases?
Yes, for the civil cases. If you commit a crime there, you're on your own. You can't go and rape somebody and say, my father and your father will sit down and settle it. No, that one is not. It's a no. That one, it's a crime against the Republic, and the Republic will take the case up. You get it? So I think that even by the design of our rules, it allows for an attempted out-of-court settlement before you start the court process. You get it? I am thinking that the reason we see these delays, some come from the lawyers themselves, others from like the Honorable Katie, who went with his election, challenged his election results and decided not to go to court. When the judge was dismissing the case, the judge made that statement. I'm not the one saying it, that the man, after bringing the initiating the case, decided not to show for the case. And there are a number of cases like that in court. There are a number of cases. There was a joke that
them, actually.
The
people abandon the cases in the court.
So they will take you to court and run away and leave you in court. So there's always an adjournment. The case comes up. Then the person who has taken you to court is not there.
They are looking for you. They cannot find you.
They can't find you. So you, who has been taken to court, the defendant, you are the one now saddled with whatever. So if you are also a patriotic citizen, you respect the court, you want to attend to the court or attend upon the court at all sittings, then you are the one who keeps going to court. But the person who has actually initiated the case has run away.
See, there are a lot of factors that are contributing to this. There's the backlog of cases. There are courts that should be handling about 250 cases a year, but they are doing like over 800 cases. So some of them will travel into the next year, and they keep adding onto the numbers. Although the judges and the magistrates, they will try as much as they can to deal with the cases, how do people call it, expeditiously, but sometimes it is beyond them. Imagine you have maybe 15 cases to deal with in a day, and then you call the cases, maybe time for cross-examination. Lawyer asks 4 questions, another lawyer asks 4 questions. There are a lot of questions to ask to establish what you want to establish, but you don't have the time. If you decide to give 4 hours to one case, then what happens to the other 15 that you have to deal with? It means that one case that you could possibly have gone a long way to maybe deal with it halfway, you have to stop it at the beginning, adjourn it to another day so that you can deal with another case that same day. We keep doing this, and then we keep
one of my
adding.
lecturers made a joke about some lawyers. Say some lawyers are called adjournment lawyer.
So we keep moving dates, changing dates, adjourning, sometimes through no fault of theirs, just by virtue or just by the fact that the cases are a lot, and then you have to deal with all of them because lives are at stake, families are at stake, institutions are at stake, a lot of things are at stake. Are we able to deal with it eventually?
I did my internship in one of the courts. And when you do these internships, you come across closely in contact with the judge.
You experience them.
So you see things from the side of the bench.
Yeah.
Because then you are serving as a clerk to the judge. And that was one of the cases. In fact, the judge I served under was dealing with a backlog of cases that had piled up.
I'm guessing from previous judges.
Yes. So she had been taken to that court as, let me say, a new judge. And she went to meet a backlog of cases. So she had to go through all of them and try to deal with the backlog before starting with the freshly instituted ones.
The ones
And on a daily basis, cases are coming.
Charlie.
So as much as you clear the backlog, the front log also keeps piling up. So I think that the CJ would definitely have to pay particular attention to this. And it is really not a question of people, respectfully. People who like litigating. It's a systemic problem. It's a systemic problem. Some lawyers also have been accused of deliberately frustrating prosecutions.
That we know very
and
well.
Litigation.
Particularly in the politically.
That is also very arguable. I mean, I'm a lawyer. I'm doing what
yes, to the best of your ability
of my client.
In the best interest of your client. Yes, that is true.
Some way.
So long as it serves the interest of your client, you think you are doing your best. But remember that the lawyer is also an officer of the court, and part of that responsibility is to ensure a free, fair, speedy trial, so that you don't take somebody to court. You are keeping the person in court. The person has businesses he has to attend to, but cannot move because he has to come to court every day. Charlie, going to court is not a small thing. You go, a lawyer is supposed to file something. By the time the court sits, the lawyer has not filed the thing. Okay, my lord, we pray for an adjournment so that we can file 1, 2, 3. Meanwhile, between the last court dates and the present, you had like a month or so, and these cases are adjourned for weeks.
If he files it early, the case is dealt with early. His clients may go to prison early. He does not want that. So
well, that is somebody has also brought that up as a strategy. That in especially politically charged cases, you find some of the lawyers who are delaying or dragging the cases because they are hoping to travel into the next political dispensation. To gain some favor. All those are tricks that are delaying cases.
So it means that it should be the system that should be able to check these, because
exactly
the individuals, I mean, they would want to, like we're saying, do what is in the best interest of their client, because they're the ones paying them. So the system should make sure that something like this is dealt with. Make it very difficult for people to go around the regulations, the spaces available. He mentioned the 24-hour courts running for 24 hours. How will that contribute significantly to solving this problem? Even if we're sitting in the evening, and then, like we're saying, a lawyer comes and then prays for an adjournment, it does not change, it does not solve much of a problem, because it's the same lawyer using or taking advantage of that same system, although you would think that you have brought measures to reduce it. We have to look at practices, introductions, policies that can properly deal with this problem of adjournment, of all of those case management.
But there's a danger there too. Justice delivery is not about speed.
Exactly. You can,
because if
in deciding to do it in a hurry, you could violate the right of the
other person. Look, you see what happened in Parliament yesterday between the majority leader and the minority leader. Take that as a typical court session. Okay. So long as it does not, so take Afenyo as the prosecutor and take Ayarga as the defense lawyer. So long as a word, a phrase paints the defense attorney's client in a bad light, he will object to it.
He will not allow it to go.
He will not allow it to go. And you cannot say he's wasting time, because he has to ensure that his client's best interest is served. I don't know who the client will be in this case. Will it be the former CJ or the...
Don't go there, leave it like that.
So take that as a typical court session, and you will understand the problem that the courts are faced with. The judge. And so long as an objection is raised, the judge will have to take it, go look at it legally, and rule on it. There are some of the objections that the judge cannot give a bench ruling. He would have to recess, reason the ruling before you can proceed.
Because if he does not do it, you the same lawyer, you come and
say he is biased.
And then you go and appeal.
You go and come back. And no judge wants his decisions to be appealed. No judge wants
like it.
No judge. Because it questions your competence, your knowledge. So we are all saying that the process is delay and all of that. But some way, somehow, we are all part of the delays. Look, in other jurisdictions, when you take a case, like the finance minister's case, finance minister Seydou Agongo, there was a third person. Like that case.
The ambulance trial.
The ambulance case.
And a host of others which have come and gone.
Jakpa.
That was ambulance case.
Yes.
Ambulance purchase.
Yes.
Yeah.
In other jurisdictions, that case could have been heard in 3 months.
But in our case, it lasted longer.
I think we're in the 3rd year or 2nd year. That case would have been heard in 3 months. Because by the time the prosecution says they are picking you up, it means they are ready.
Everything is ready.
Everything is ready. Everything is intact. The prosecution opens, they flow, and they go according to the timelines set and agreed upon by all the parties in the case.
Right. Let me bring in Christian Yali. He was in Parliament for us. Also, we've been joined on the phone lines by Professor David Abdullahi. He's on the board of the Africa Parliamentary Network. Christian, you were in Parliament for us yesterday as well. It will be nice to get a bit more in terms of the perspective, even before I go to Prof on the phone lines for a bit in terms of the analysis of the conduct and what transpired, and then subsequently the decision of the minority to leave. But you were there. Describe to us the mood before and after the minority decided to leave. Was it one that you suggest there was bad blood after the heckling which happened when the minority leader was seeking to make his point?
Yes, you can describe it as such. In fact, before the vetting itself would begin or the meeting would be called to a session, I had engaged few of the minority MPs on the committee who had expressly indicated that they were there to cooperate, and I was very, emphatic in always asking them about their cooperation and whether they were ready to cooperate. I asked the likes of Kwame Ayumedu-Entry, who was one of the sponsors, who sent a motion to the Speaker asking that the vetting be put on hold. I spoke with Patrick Boama as well, who is actually the chairperson of the subsidiary legislation, and then the likes of Bafo Ewua and a host of a few others who I engaged, and they were all almost whipping in the same line that they were ready to cooperate, and for them to even show up, that meant a lot. And so the expectation was that you would get that same cooperation, that same, democratic civility or more or less, to see that the vetting would happen smoothly without any hecklings and all of those drama that we witnessed yesterday. But it turned out to be the other way around. Indeed, if you asked me, I, in fact, did not even expect them there in the first place, which would have been a total boycott. But we saw them come and later walk out. When the minority leader indicated that he had a preliminary remark to make, that was when I sensed that there was going to be a very different twist to the whole vetting process. Also because when you look at the standing orders, it does not state explicitly that it is mandatory for the ranking
someone to be making a comment.
Yes, a preliminary comment, so to speak.
That has come about because it's become more of I don't want to use the way I don't want to use the word convention. So a practice, possibly because it's been more recent to have them them make these comments. Let me get onto the phone lines. I'll return to you, Christian, in the aftermath of when they left. Prof, I appreciate you joining us and holding the line for us as well. In terms of what we saw play out from the minority side, what would you describe it as? Forcefully making their point that they reject the nomination of the CJ and that they will walk out afterwards, and just simply making their point?
Well, first, good morning to you and the listeners. I think I made it clear on this show that they were going to walk out. You remember the last interview that I joined?
Yes.
So I didn't see it as anything. I think what they wanted to do is that at least for the world or whoever is watching to see or to hear what they had to say. So coming there and saying that they were willing to cooperate, it wasn't. It's neither here nor there. I think it was a ploy for them to put across what they had to say. Now I have to give them credit for showing up because they had kicked against this in arguments at the plenary until the speaker, said there's no way that they are going to stop the vetting. And I think, leadership doesn't mean that you must win all the time. If people disagree or agree, whatever it is, the national duty should have taken place. That preliminary introduction or whatever he had to say should have been just general, and then they can then insert most of the things that they wanted to ask within the vetting itself whilst the nominated Chief Justice was there. But what they have done, in my opinion, they have missed the opportunity to have been able to ask all the tough questions they had and to actually really show the world that they contributed to such a national appointment. Because Ghana cannot deal without a Chief Justice for a very, very long time. We all know that. But they didn't do that. So at this particular case, I heard them saying that they are going to debate at the plenary when they send the report to the plenary. What are you going to debate about if you didn't contribute to asking any questions? So for me, I didn't support the idea that they had to walk out.
One of the justifications for walking out, and Sixes has been here, has been seeking to explain because he's engaged a number of the NPP MPs as well. They say that, look, they were being heckled when the minority leader was seeking to make his preliminary comments, and as such, they didn't think they would have had it smooth in asking questions as well. And so that's why they decided to leave after the statement as well, because from the posturing of the majority, it was such that whatever question they were going to ask was going to be put under the microscope, and so they did not want to be a part of a process like that.
I think leadership is not a popularity contest, but we all know the minority leader and what he does at most of these committee hearings. I mean, you see, when you set such a track record, what is happening now? People will even believe you. Let's assume that all those kind of theatrics in the previous committee hearings hadn't taken place. Then people will say yes. But right now, you even realize the time where Ananda and others had to turn tables down, break things during a committee hearing. You expect us to believe them now that this is what they are going to do? No, I don't think so. And also, you are leaders. If you are heckled because of that, you should throw in the towel. Oh, let them heckle you. You have a point. You want something to be put out there for the world and even for Ghanaians to see. But the action to me is, I look at it as childish.
Childish that they decided to walk away and not be a part of the process.
Well, you're a leader. So are you telling me that when you're a leader and you go for an event and your opponents are heckling you, you just give up and go away? I don't think so. I think you have to. That is actually when you have to stand your ground. And whatever it is, when they throw lemons at you, you make it into lemonade. If they throw bricks at you, you build a wall. You just don't throw in the towel. That to me is not on. If our our politics has to mature, if our democracy has to mature, you have to have a thick skin.
To the extent they argue it is well within their right, and like you had suggested, even you weren't expecting them to have been present because of all of the concerns they had raised. They would just say that they were exercising that right to stage a walkout and not be present. They just made that showing, make their preliminary comment, and then they leave the rest to you, and you come and meet them on the floor of the House.
Well, if you have decided to come, why did you decide to come? Did you decide to come to think about the fact that if they heckle you, you are going to walk away? No. You have decided to come because you want to participate. And they actually said they wanted to participate in a national duty. So if you are to participate in a national duty and because you are being taunted or heckled by your opponents, you have to stay and make sure that you make it very clear. Or otherwise, when you are giving your statement, you could make it in such a way that you go by the rules, as the majority leader was saying. I think I don't have to even mention some of those things, and I can get my words across. It all depends on my delivery. I don't have to mention those same words, but I can get my issues across. And to me, that is what should have been done very briefly, and you move on. If you go to the House of the Chiefs in this country, when they speak in parables. They speak in such a way that whatever they want to say, they can say it without actually offending anybody. Are you with me?
Yes, I am.
So I expected that, if you go here and this is what this guy says, oh, you cannot do this. Okay, so I come and I say something that can get me across without mentioning those things. It's leadership. You have to know how to do the delivery. So for me, they have missed a golden opportunity to really have put across what they wanted to say. But I knew they were going to walk out. I mean, I think I said that much earlier. So I wasn't surprised when it happened. I wasn't really surprised.
Let's talk about whether or not it took something away from the process, because for many, we know that more often than not, the minority is the one that serves as the agent who pose the most difficult of questions and seek to probe the most whenever it is a government-nominated individual coming before the Parliament Appointment Committee. Would you say you were impressed with the questions that came forth from the majority side who took over and conducted affairs of the Appointment Committee?
I was very impressed. And you saw that they really wanted to find out, this vast experience of the nominee. They also wanted to find out his experience. And also, he answered with, innovative ways. He's going to bring about artificial intelligence, make sure that, they come up with infrastructure for the courts and other things. And that is what we wanted. So actually, by the minority walking away, it didn't take away anything. The only thing is that it took away a little shine because they were not there. But whether they like it or not, I mean, this is a democracy. The majority are the super majority. So, I mean, you should know that if you want to make an impact, even though you are a minority, you should be there and ask those tough questions. But once they were not there, they never had the opportunity. So if you don't get to ask the questions and you are not the majority, some people regard what they have done as theatrics. And to me, that is sad. The only shine is that, it will say the minority were not present. So, whether they like it or not, the guy is going to be voted as
as a new Chief Justice. And
no one can say it's not correct. He had to go through the
the process.
But also, when the minority argued in the plenary in Parliament that they should not hold it, the vetting. What did the Speaker say? He said, if you do this, it's going to be a precedent that will have an impact on the work of Parliament, which is by separation of powers, it's a different body, So the Speaker said, anytime, therefore, if this is done, anytime, therefore, anybody has an issue in court, then the Parliament cannot act on its legitimate duties until that case is cleared. And the process in this country, when you take a case to court, it takes forever. And I think some of my colleagues on the show were talking about what happened to Agongo and Co. and so on and so forth. Look at how many years it took, and it's not supposed to be.
Right.
So I think for democracy to move ahead in this country, look, I should agree to disagree with you, but that shouldn't stop the process, and I think that is it. Now, the third chapter is that the minority leader was also a majority leader. Remember, there were some times they even worked out on the minority at that time. So
during the budget, I recall that very well.
Yes, so it's nothing new. So if they work out, it's their right to work out. But I'm saying that they've lost the opportunity, And at the end of the day, they might have had the satisfaction of working out, but at the end of the day, they have missed the opportunity to really have asked the Chief Justice nominee the tough questions that probably the majority didn't ask.
Prof, I appreciate you joining us and sharing these thoughts with us.
Thank you.
Yeah. That's Prof. David Abdullahi speaking to us, the board chair of the Africa Parliamentary Network. Christian Yale is still with me in studio. Christian, so you've heard Prof as well. Did that come up? I mean, in terms of the fact that a certain level of scrutiny was not associated with the questioning because the minority had left.
That would be a concern or an assumption, but I can also tell you that there were quite a number of questions posed by members of the majority on the committee that sought to, elicit that kind of response. And especially when you look at that intervention made by the majority leader in seeking to ask questions pertaining to the concerns of the minority, i.e., whether the his appointment is merited or not.
Yeah, I think it was one of the very early questions he was asked.
Yes.
Whether or not he was competent to handle the position.
Exactly. And even that resurfaced later, which he sought to even rehash and make the point that he has worked under all the various presidents in the Fourth Republic. I mean, what comes to mind readily is from even President Kufuor, John Evans Atta Mills, President Mahama first term, Akufo-Addo, and then President Mahama yet again in a second term. So one cannot even seek to make a point that because of his vote pattern in the 2013 election petition, his appointment is a reward by President Mahama for that action he took in the past. But yet again, there is or was that question about whether he has intentionally decided to delay empaneling judges to decide a substantive case by Gertrude Torkornoo.
It was chief of the accusations by the minority against him.
Exactly, which is one of the major anchors for their walkout. One of the cases they have sought to make almost always whenever this issue comes out. So those questions were very, very, very legitimate and were good interventions made by, but all the same, you would always appreciate a minority effect in such, democratic process, because certainly they would seek to ask tougher questions or questions that would more or less seek to probe the person before the committee further, because then the assumption is that if you're on the majority side, you will seek to more or less sing praises. But yet again, the vetting process in and of itself, when you look at, and even one of the reasons the minority would decide to come, is to more or less, what one would argue is to ensure that their case is captured by the Hansard, because then they've sought to make that case over and over again. So this is another opportunity for us to make our case known so that it is captured in the Hansard, that indeed on record we are known to have made this case and made it quite strongly.
But they didn't even get the pleasure of that.
They didn't get it, because if you are being objected or interjected every step, every second of the way, then indeed
they are asking that it be
you wouldn't survive. Exactly, you wouldn't survive. And I think the majority leader had picked that signal and came prepared. Indeed, there are many who have not seen him
in such a light.
Yes, exactly. Because for him to even say that you cannot run down people and have your way because you are Afenyo marking means that he had been pushed to a limit. And at the point it was getting very heated that the chairperson had to call for an early break to allow cool heads to prevail.
And you were there when that early break came. Was there engagement such that it will have them return? Because for a lot of us who were watching, because I was on air at the time and we engaged while I was on air on TV, we're seeking to find out, was there an engagement such that when they return, both sides would have resolved all of the behind the scenes fracas and then proceed with the vetting? Because everybody expected that once the minority were there, they were going to see through the process.
There was no engagement, and that is because I engaged the vice chair of the committee after proceedings ended, Kweku Rickett-Hagen, who more or less indicated that you cannot have a conclave. Ordinarily, that should be the case.
Right.
Because if you're having a disagreement, then it is expected that leadership from both sides go into conclave and they're able to iron out their differences. Our expectation even was that after they resumed from that break, things would have resumed smoothly or gone on smoothly.
Yeah.
But we came back to the objections again. And Kweku Rickett-Hagen told me that you cannot have a conclave when you invite someone and the person is not willing or ready to because I had even picked signal that the minority leader was outside the President of Parliament, so I didn't even expect him to have come back, which means that effort to have a one-on-one conversation or conclave yielded no result. And so basically that's all that panned out. But indeed, it is expected that today, when plenary sit, those concerns would, ordinarily, and as it were yesterday, even right after walking out, they held a presser. We are expecting more of that indeed, and even how they are going to react on the floor. The expectation is that the report from the committee would be laid before the House this week or early next week for consideration and possibly approval of the CJ nominee.
Christian, thank you very much for joining us in studio this morning. That's my colleague Christian Yali, helping us through the processes as transpired yesterday in the legislature from Parliament.
The best in the morning.